Because this country of ours, we have to save it. And I've always said many, many times, 100 years from now, we may not be available. All of us will be dead. But we ask ourselves, what have we left for us and the future generations? As a general rule, let us try to make a society a better place than we found it. My name is Dr. Magare Gikenyi. I'm a consultant trauma and general surgeon within the county government of Nakuru. I'm a human rights and a constitutional defender in this great republic of ours of Kenya. We filed a petition, a constitutional petition, before High Court in Nakuru, mainly based on what I call external procurement of advocates to public entities. So what necessitated is that if you look Kenya in the bigger picture, you come to realize that if you look at the Auditor General report of 2023-2024, it lists counties and the national government with huge pending bills. So even the recent case where one of the farms was awarded 243 million shillings for one case. This is my opinion. If you check well within the constitutional provision, it was our view that it is against constitutional provision, both in spirit and in word. So that's why we moved to court. We filed the petition. In addition, we filed for conservatory orders, which were granted on the 12th of this month, 12th of January 2026. What are the grounds? The grounds for the same, in addition, we filed me, Okio Mtata, Philemon Abuga, Kaka Sharum, and who else? Addition Mogire, among others. The challenge we have as a society is that there is money which we make as Kenyans, but in terms of usage, it's in my view that it is not prudent use of financial resources. For example, if you check Article 156 of Article 7, it provides the Honorable Attorney General can represent the national government in court and in any proceedings. He or she can represent herself or through other subordinates and state councils. Despite these clear provisions, the county government and the national government continues to hire private lawyers and advocates. They attribute this through what they call leave for procurement of legal services, as provided in Article 227 sub Article 1. However, they fail to note that in that same article, it says that, for example, that when you are procuring goods and services, the same should be competitive, merit-based, and most important, cost-effectiveness. Then one asks, what is the rationale as a government, county government, national government, and even state corporations, advertising for positions of state councils, county attorneys, county legal officers, solicitor general, both county solicitor general and national solicitor general. And then they do what is called competitive recruitment, as provided in Article 232 of the Constitution. Having selected and recruited those state councils, whom Kenyans are paying every month, then they go ahead and leave those ones just relaxing or idling something. Then they now say that this we want to hire more external advocates. I have no personal problem with the advocates because they are a good profession and they need to be supported wherever to can. But what we are saying is that have a prudent use of financial resources. If you check Article 2:1 of the Constitution, it specifically says public money should be used prudently. There must be prudent use of public financial resources. That's a constitutional provision. And in fact, it says it must be accountable. So that's what we are saying. Why are we employing county attorneys and all the state councils? We have almost 1,000 plus state councils. But then instead of using them, what do? We go to the private advocates. In addition to that, the Kenyans, in their wisdom, by virtue of Article 230, wanted to control what they call the wage bill of Kenyans. It established a commission which is called Salaries and Remuneration Commission. This is the one which was supposed to regulate salaries for both public officers and state officers. But then, by them, this so-called procured advocate come to the public service, they are offering public service. So by virtue of offering public services, they should be paid according to the public service rates. But what happens in this rate is that their rate of remuneration depends on what we call Advocates Act, Section 44 and 45 of the Advocates Act, as read with Section the 5th schedule of the remuneration order, which essentially says that even if the advocate has come from the private, has come to work in the government, his or her payment is dependent on the remuneration order. This remuneration order was specifically for advocates in the private sector. In the public sector, payment of all monies through the public sector is regulated by public service commissions, regulations, and principles. So you find that among the things they say that they can decide how much they get paid for themselves, based on what they call complexity of the case and other circumstances of the case. What are the other circumstances? So I think that's what we were saying. I think if you look at what they call purposive interpretation of the Constitution as provided in Article 259, then it means each constitutional provision should support one another. You cannot pick one constitutional provision and say it's superior than the other. The other allegation, they are saying that why people hire external lawyers is that every person, including county government and national government, have a right of legal representation. So, but then now the second question comes. That the same government have recruited, have advertised, people have applied, they have picked, ostensibly they have picked the best advocates. They have recruited them. But when now the case comes that they're supposed to do the work they were employed to, then now they say now they have a right to pick the best advocate. And then they pick it from the private services. And in fact, an audit was done last year through the office of the Attorney General. It was found 80% of external lawyers lose cases, 80%. So this means for eight cases, only 2 of us are assisted as Kenyans. When we lose 8 cases out of 10, what that one means, we have double tragedy. Not triple. Number one, we have employed state council who are supposed to do work. They have not done. So they're just earning. They're doing what they're supposed to do. That's the first thing. Number 2, we have employed private counsels whom we are supposed to pay. That's the second one. The third part is that we have lost the case. If we have used our counsels, we would have had one loss of the case. We pay just the cost of that case. But when we lose the case, we pay the cost of that case, we pay the advocate, because advocates get paid whether he loses or gains. Because he or she has offered service, and it's well, that's okay. So that's what we're saying, as a society, we need to think globally and find what's the best way forward. Because as you realize, this country of ours, this is our country. Nobody's going anywhere. We need to protect the meager resources which we have. So when we see resources are being plundered left side and center, we must come and say this is wrong. We need to do A, B, C, D and make sure everything is right. That's why I'm saying that we need to do the same. And I've always said many, many times, lawyers and advocates are excellent professionals, and they need to be supported. They are good people, and I have no problem with that. But personally, I have even friends and close relatives who are advocates. So, but then what we're currently saying is that number one, there must be prudent use of scarce financial resources, so that we have enough money which can assist us to build roads, education, infrastructure, among other things. The court essentially agreed that the court, first the court gave conservatory orders. These are just orders waiting for the hearing and determination of the petition. So the court allowed our application, ex parte conservatory orders, waiting for hearing and determination of the main petition. That's where we are. And there's an inter parte hearing on the 30th of January 2026, where all of us as petitioner will be there, including Njuguna Ngatia, who was also one of the petitioners, the 6th petitioner, Okio Mtata, Abuga, among others. All of us will be there on that day, so that we can also, whatever issue which comes up, we prosecute our case, and we believe we will win the main petition, because the grounds we have are substantive in nature, and they cannot, in our view, we will convince the court that those grounds and allow the petition as prayed. That's where we are as we talk.
What will the win mean to Kenyans?
What the win will mean is that to Kenyans, number one, we will be using our those state councils and the county councils which have already been employed. Currently, we have a lot of state councils doing their work. When these so-called political cases come, they look for private firms. And more than not, they are a political resort, not even competitive resort. So then at the end of the day, we need to have to ensure that then we will save our monies. Our funds will be saved. Because if you realize money as a resource is always scarce, always. That's why we say that we need to use this money prudently. Because if you check Article 10, it says that, for example, that we need to have what you call equity, fairness, good governance, among others. So if you have, for example, you do those things which are against the Constitution, then it means we are going against the constitutional provisions. So those are things we are trying to put across. Because if you check Article 237, even those aspects must have cost effectiveness. Article 201 says we must have cost effectiveness. That's in 227. Then prudent use of financial resources in Article 201, A and D. A is on accountability. D is prudent use of financial resources. Then Article 230 of the Constitution says that we have SRC which controls the wage bill. We cannot have a Constitutional Commission which controls the wage bill. Then you circumvent the same through application what we call a procurement limb. Those are the things we are trying to put across so that we can protect our money and save. Currently, we have a legal fees wage bill of 56 billion for the counties. Nairobi County alone, Nairobi City County, has a bill of 21 billion for advocates. I'm very sure you heard there's one lawyer who was awarded 1.4 billion. One lawyer or one law firm, 1.4 billion legal fees. Just imagine what a billion can do. Just 1.4, that's 1.5 billions. So those are things we're trying to put across. The justification, they always say that even this bill which we are complaining as activists, that it was done by the deputy registrar, it was done well, but they have missed the point. The argument we are saying that the bill which we are complaining about has been due to Advocates Act, a statute. A statute is not supreme in the Constitution. This statute is the one which allows an advocate, when he comes from the private sector to the public, instead of being paid at the rates of the government, they get paid at the rates of the private sector. Which essentially means, that's why you can see that they are allowed under the what they call remuneration order. The amount to be paid depends, among others, complexity and other circumstances of the case. So if I do a case and I think there is other circumstances, which means I can be paid 100,000, I can be paid. There's always a percentage of the value, then like that. But if, for example, all those aspects, since we have employed state councils, they would have done the same, and we would have saved a lot of money. Because this country of ours, we have to save it. And I've always said many, many times, 100 years from now, we may not be available. All of us will be dead. But we ask ourselves, what have we left for us and the future generations? As a general rule, let us try to make a society a better place than we found it. That's what I can say.